The first step in starting a cerebral palsy claim will be to discuss your recollection of events to obtain an initial understanding of your pregnancy, labour, delivery and your child's neonatal care, the areas where the care provided might be criticised and the likely consequences of any failings in care. We will discuss your funding options with you and enter into a funding agreement. The choice is generally between legal aid funding and funding under a conditional fee agreement with associated insurance. With either form of funding, there should be no cost to you if the claim is not successful. When successful, there will be a clear understanding of the situations in which the court might order a payment from the compensation award to meet specific costs which we cannot recover from the defendant. We will obtain the relevant medical records, including brain scans from the hospital and the GP. We will appoint independent medical experts in the appropriate disciplines. They will consider the standard of care provided to you and your child, the timing and cause of your child's cerebral palsy, and whether, had appropriate care been provided, the injury would have been avoided. Generally, experts in the disciplines of midwifery, obstetrics, neonatology, paediatric neurology and neuroradiology are required. Depending on the issues in your child's claim, we may also require experts in the disciplines of paediatrics, paediatric infectious diseases and microbiology. We discuss the experts' views in conference with you and a specialist barrister in order to ensure we've covered all the possible issues that may arise and prepare a formal pre-action letter of claim setting out the facts together with our allegations of breach of duty and causation of injury. The defendant will then investigate the issues, obtaining its own expert evidence and provide a formal letter of response. The letter of response will admit or deny the claim. If the claim is admitted, we enter judgment and obtain a substantial payment of compensation to meet immediate and ongoing needs. We also discuss with you and experts whether your child's prognosis and future needs can be ascertained with sufficient certainty at that point for the court to make a final award of compensation, and if not, at what age your child's prognosis and future needs can be assessed with sufficient certainty for a final court award to be made. If the claim is denied, we will commence formal court proceedings. The court will make an order timetabling the necessary steps to be taken before trial and set a nominal trial date. In most cases, the defendant will admit the claim at some point during the court proceedings and before trial, or we will be able to agree terms of settlement with the defendant subject to the approval of the court and so avoid the risks of trial.